Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss section 32 of Indian Evidence Act. So friends, section 32 is quite big, but still I will try to conclude this lecture within 30 minutes. Let's see. Okay, so friends, if you have your Bear Act with you, please open it up. Open section 32 very quickly. Cases in which statement of relevant fact by person who is dead or cannot be found is relevant. Statements written or verbal of relevant facts made by a person who is dead, who cannot be found, who has become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appear to the court unreasonable, are themselves relevant facts in the following case. Okay, friends. So this first part of section 32 is providing you for certain requirements. Okay, there are three main requirements that this first part is talking about. The first point that this first part is clarifying is that the statement which is admissible under section 32 can be either written statement or can be a oral statement. This is the first point that you must remember. The second important point that you must remember is that the statement must be in relation to relevant facts. This is very important. And what are relevant facts, friends? Relevant facts we have already covered from section 6 to section 16. It must be in relation to relevant facts. Third and the most important part of this section 32 is that the person who is making the statement or the person whose statements you are trying to admit in a court of law is not available before the court. Okay, and what may be the reason for non-availability? It may be that the person has died. It may be that the person has been lost, he cannot be found. It may be that the person is incapable of giving evidence, for example, because of unsoundness of mind, or it may be that the person is so far away that his presence in the court of law will involve a lot of delay and expenses, which the court considers to be unreasonable. Okay, friends. So in these four circumstances, if any statement which is in either written form or verbal form which is relating to relevant facts can be admitted under the following circumstances. So the following part mentions 8 circumstances when a statement satisfying all these 3 conditions are admitted. Okay, friends. So what is the first circumstance? First circumstance deals with dying declaration. It says when it relates to cause of death, when a statement relates to cause of death, when the statement is made by a person as to cause of his death, very important, or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. Such statements are relevant whether the person who made them was or was not at the time when they were made under expectation of death, and whatever may be the nature of the proceedings in which the cause of his death comes into question. So friends, as far as this first circumstance of dying declaration is concerned, there are 5 points that you must remember always. Okay, first is that the person whose statements you are trying to admit has died. He is no longer there, he is not alive. This is the first requirement. Second requirement is that the statement you want to admit is relating to the death of this person, cause of death of that person, or any other circumstance which is relating to the transaction of transaction of death of that person. Okay, this is the second requirement. Statement must be relating to cause of death or transaction which resulted in that. Finally, and the third requirement is that these statements can be admitted only in those cases where the question is relating to the death of this person. Okay, where the question is relating to the death of this person before the court of law, only in those cases these statements can be admitted. What is the fourth point provided by second part? That these statements, for the admissibility of these statements, it is not required that the statements when they were made by the person who has died, he was expecting his death, or he was actually aware about that death is going to occur to him very soon. No, it is not necessary. A statement made by that person in normal circumstances will equally be relevant and admissible. Oh, so okay. So expectancy of death at the time of making of statement is not required. And finally, the fifth point, which is related to the third point, it says that though it is necessary that these statements will be relevant and admissible only in those cases where the question of death comes into before the court of law, but it makes no difference. As per the fifth point, it makes no difference what is the nature of the proceeding. It can be civil proceeding or it can be criminal proceeding. Okay, so the nature of proceeding will not differentiate, but the one of the questions should be relating to the death of the person, right? So five circumstances in all for what, friends? Dying declaration. Again, a quick review. Why I am doing quick review? Because it is very important. The first is the person has died. Second, the statement was related to cause of death or any transaction which resulted into death. Third question is it is being admitted in a case where the person's death is in question. Fourth is that it is not necessary that the person must be expecting death. And finally, it does not, the nature of the proceedings does not make any change. They are admissible in both category of proceedings. Okay, this is our dying declaration. So for understanding dying declaration better, we will see illustration 1. Illustration 1 is quite big, so don't get confused. Okay, so illustration 1 provides for three scenarios. The first scenario is, the question is whether A was murdered by B. So this is a very simple scenario. First scenario, that a particular person A has been murdered by B. What is the second scenario? A, so these are independent facts. Okay, independent, don't interconnect them. The term or is used. A dies of injuries received in a transaction in the course of which she was ravished. The question is whether she was ravished by B. So in the second scenario, what are the facts? That this person A is a woman. She has died, and she has died while rape was being committed on her. So the question in this case is whether B has committed rape or not. Okay, what is the third circumstance, third scenario? The question is whether A was killed by B under such circumstances that a suit would lie against B by A's widow. Okay, so a civil suit for maintenance and everything, for whatever rights A's widow may have, because A has been killed by B. Okay, so these are the third facts. In the third scenario, what is happening? A has been killed by B. In such situation, that A's wife can prosecute B in a civil proceeding. A suit can be brought for that. Okay, we'll not go into the details of that. So these are the three scenarios before us. In the first scenario, A was murdered by B. Very simply. In the second scenario, A died during the occurrence of rape on her by B. In the third, A was killed by B. Okay, very simple. Now, what are the statements that will become relevant under section 32, circumstance 1? Statements made by A. So A is common in all. A in the first circumstance who was murdered by B, A in the second circumstance who was raped by B, and A in the third circumstance who again was murdered by B. So statements made by A as to the cause of his death. Before his death, whatever statements he made regarding cause of his death, his or her death, in B is she is a woman, referring respectively to the murder, okay, to the rape, because rape resulted in murder. Rape resulted in murder. Rape was the cause of death. That is why the statements in regard to rape are also becoming relevant. And any other actionable wrong under consideration. Actionable wrong under consideration because of third point. That actionable wrong which is arising because A has been killed by B. Actionable wrong which is being brought by the wife of A. Okay. Then why facts regarding statements regarding actionable wrong are becoming relevant? Because they are dependent on the death of A. Murder of A by B. Okay, all these three facts will be relevant. So the statements of A regarding, very simple, regarding the cause of his or her death, or this is the first requirement, that cause of his death, and these statements may in detail refer to the murder or the rape or actionable wrong, because all these 3 points are are the things which actually are directly connected with the cause of his or her death. Okay, friends, so it is quite complicated. It is evidence law. It will not know it in like substantive law. It will not just hit you back. Okay, this is what it is. It will take time. But again, don't get confused by the illustration. But what are the requirements that we need to keep in mind as far as one is concerned? We have already covered. What are those requirements? The person has died. The statement he's making is related to the cause of his death or the transaction which resulted in that. And the third requirement was that this issue, the statement is being admissible only in those cases where the person's death is in question. And fourthly, expectancy of murder on the part of the person who has died is not required. And finally, the last point is that the nature of proceedings does not matter. Okay, friends, these are the 5 requirements of dying declaration. Now come to the second circumstance. Or is made in the course of business. When the statement was made by such person in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him in books kept in the ordinary course of business, or in the discharge of professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods, security, property of any kind, or of a document used in commerce written or signed by him, or of the date of a letter or other document usually dated, written or signed by him. Okay, so what is happening under second? How second is different from first? So friend, in first we were only focusing on one kind of circumstances in which the person has died. But as far as second is concerned, we are covering all the 4 category of circumstances that were mentioned in the first part we discussed. In this case, for the application of second, it may happen either the person has died, or either the person has been lost, or he is incapable of disposing, or he is far away. So it will involve expense and delay. Okay. So for all those 4 circumstances, second can be applied. After this, what are the essential requirements? That the statement you are trying to admit, the statement of the person who is falling under any of these 4 categories, that he has died or incapable, whatever, the statement of such person must be in the ordinary course of business. In the ordinary course of business. What is ordinary course of business? Ordinary course of business means which involves day-to-day activity, which is not influenced by any special circumstances. These are the things what every particular person does as part of his or her job, or is the business. Okay, so it is ordinary course of business. Okay, so whatever a particular person says, or whatever a particular person writes in the ordinary course of business becomes relevant, because if that person who made that statement is not available before the court of law. Okay, so all these statements which were made by that person in the ordinary course of business, all those statements become relevant. Okay, now the rest of the para regarding second is only explaining what are the things that we will include this term ordinary course of business. Okay, what are the things that will be included in ordinary course of business? In particular, that it consists of any entry or memorandum made by him in books kept in the ordinary course of business. So if a particular person makes an entry in his diary, or in a particular book, or in a particular memorandum every day as part of his ordinary course of business, so all those statements can be brought before the court of law if that person is no longer alive, or is lost, or is of unsound mind. Okay, what is the second example? Or in the discharge of a professional duty, or these statements or these diary can be maintained for business or for a professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods, security, or property of any kind. So if there is a particular document which is a receipt of money, that I have received this money, I have received this goods, I have received this securities, I have received this property, and he has made a particular statement on that paper. Now if that person is not available, this statement can be brought before the court of law and can be admitted, because that statement was made in the ordinary course of business. Okay, and finally, or of a document used in commerce written or signed by him. So this part includes all the other category of documents which are used every day in commercial activities. Okay, so whatever statements are written on those documents, they can be brought before the court of law if that person is not available. And of the date of a letter or other document usually dated, written, or signed by him. Okay, so 2 important things has been specifically made relevant. What are those things? One thing is about the date. The dates which are mentioned, they are also statements. If a particular document is mentioning a date, that this document was executed on this date, so that date is in itself is a statement. that is also admissible if that is this date is written by such a person. And the second important is the signature of that person, the signature of the person who is not available, that is also a statement. So those signature can be also brought before the court of law so as to prove that this document was actually signed by that person or not. Okay, so don't get confused. The simple rule you must remember that all those statements which a person makes in the ordinary course of business, they all of those statements can be admitted under 2 of section 32 if that person is not available before the court to dispose that fact. Okay, this is what 2 is trying to say. So for understanding 2, we will look at one illustration. Okay, the question is as to the date of A's birth. Okay, so what is the question? What is the date of birth of A? An entry in the diary of a deceased surgeon regularly kept in the course of business stating that on a given day he attended A's mother and delivered her of a son is a relevant fact. Okay, so what is the dispute? What is the date of birth of A? So if a diary is brought before a court of law in which an entry has been made by a surgeon who is no longer, who cannot be brought before the court of law for whatever reason, that he has died, he is lost, or he is become a person of unsoundness of mind. Okay, so if there is an entry in that diary which shows that on a particular day he has actually attended his mother, he had operated his mother, and the child was born and that child was delivered to his mother. So that day, what that day is doing, that day is that entry is proving the date of birth of A. So that entry in the diary can be admitted in the court of law because of this second part, because all the requirements are satisfied, that the person surgeon is not available, he cannot come before the court of law for whatever reason. And second, this entry in the diary was made in the ordinary course of business. It was not made for any it was the part of the job of the doctor to maintain diary for all these scenarios, right? So that is why this statement, this entry in the diary of the surgeon became relevant. Now quickly come to third, or against interest of the maker. When the statement is against the pecuniary and proprietary interest of the person making it, or when, if true, it would expose him or would have exposed him to a criminal prosecution or to a suit for damages. So third is very simple. It is simply saying that a statement made by a person who cannot be brought before the court of law for whatever the reason, of whatever 4 reasons that are mentioned there, if that statement is of such a nature that is against the person, is against that person only, who cannot be before that who cannot be brought before the court of law, that the nature of the statement is against the pecuniary and proprietary interest of that person himself. Pecuniary means money related, proprietary means property related. So if the statement is of such a nature which is going against the pecuniary and proprietary interest of the person who made them, then that statement can also be admitted under third circumstance. Okay, or this is the first, that the pecuniary or proprietary interest, or if the statement is of such a nature that if the statement is proved, it would expose him or would have exposed him to a criminal prosecution or suit for damages. So if this statement became true, so if that person would have been alive, or if that person would have been available before the court of law, he would have been arrested for that, or a criminal prosecution could have been started against him, or a civil suit or a suit for damages could have been started against him. So this nature of the statement is such that which is making that person liable either for criminal prosecution or for civil suit. Okay, so it is, what are the 2 requirements that you need to satisfy? The third circumstance, that a statement made by a person who has died, who is lost, who's become incapable. So this, if the statement is of such a nature which is either pecuniary or proprietary interest of that person, or it is of such a nature which is exposing this person to criminal prosecution or civil suit, then such statements are admissible under section 32. Very, very simple. So as far as third is concerned, we will again look at one illustration, that is illustration E. The question is whether rent was paid to A for certain length. The question is whether a rent was paid to A or not, whether a particular person X paid rent to A or not. A letter from A's deceased agent to A saying that he had received the rent on A's account and held it at A's order is a relevant fact. So for example, there is a case going on. A is saying A is the landowner, X is the tenant. Tenant is saying that I have paid the rent. A is saying that you have not paid the rent. So in such scenario, if a letter comes before the court of law, which is written by A's agent, landlord's agent, the letter mentions that letter mentions that rent has been received from X, and that this person A's agent is holding that rent according to the wishes of this person A, landlord. So even though the agent is not available for whatever reason, he has died or he has become a person of unsoundness mind, still this letter can be proved, can be admitted, because this statement is against the interest of the person, against the interest of the landlord. Why? But when we said that the statement is made by a person against his own interest, so the agent is representing him only. That's why statements of agents are becoming a statement of agent is becoming relevant against A, because agent was acting on his behalf only. Okay, friends. So this was the third circumstance that are covered under section 32. Now come to the fourth. Or gives opinion as to public right or custom or matters of general interest. Okay. So if a particular person who is not available before the court of law for whatever reason, if the nature of the statement is such that that person was giving an opinion in regard to a particular public right or a particular custom or any particular matter of general interest, then that statement can also be proved. So for example, if the person is of such a nature that he was, because that person was old, he was aware about a particular right or he was aware about a particular custom, so whatever statements he made before he died or before he became a person of unsound of mind, whether that statement was verbal or oral, that statement can be admitted under this fourth part of it. Okay. When the statement gives the opinion of any such person as to the existence of any public right or custom or matter of public or general interest, of the existence of which, if it existed, he would have been likely to be aware, and when such statement was made before any controversy as to such right, custom or matter had arisen. So there are three requirements for the application of this fourth. That universal requirements will remain the same, that the statement is made by such a person who is not available before the court of law for any of those four reasons. Okay, that is the same. Now the statement is of such a nature which is relating to any particular public right. This is the first requirement, which is relating to any public right, custom or general interest. The second requirement is that the person who is making the statement, because of the position he was holding, he must have been aware about this public right, custom or general interest. Only then, and the third point is that that statement must be made by that person before any controversy regarding to that right, that custom or general interest had arisen. If that statement was made after the disputes had arisen in regard to that, then it will not be relevant because it will be biased. There is a threat of the statement being biased. If the statement is made before any controversy, then it will be relevant. So what are these requirements? The statement is in regard to any particular public right, custom or general interest. The second requirement is, friends, tell me what is the second requirement? The second requirement is that position of the person is such that he must have been aware about that right or custom or general interest. And the third is that, and the final is that if the statement must be made before any dispute had arisen. This is the fourth. Now come to fifth. Or relates to existence of relationship. When the statement relates to the existence of any relationship by blood, marriage or adoption between person as to whose relationship by blood, marriage or adoption the person making the statement had special means of knowledge, and when the statement was made before the question in dispute was raised. So as far as this fifth point is concerned, it is very similar to the fourth point. In this fifth point also, there are three requirements. Okay, so the first requirement will remain the same, that the statement is made by a person who is not available to dispose before the court of law. Now the statement is of such a nature which is hinging upon, which is commenting upon any existence or non-existence of a particular relationship. So if the dispute is whether these A and B are brothers or sister, whether A and B are father and son, whether A and B are mother and son, so all these, if so all these statements which are either proving or disproving such relations, which are either commenting on the positive or negative part of them, then all these statements, if they, this is the first requirement, the statement is of such a nature which is commenting on a relationship, and the nature of the relationship can be, it can be a blood relationship, it can be a relationship by marriage, or it can be a relationship by adoption. So whatever be the relationship, nature of relationship, if it is in regard to relationship, the second is the statement is made by a such person who has special knowledge about the existence of relationship. So for example, that person is a family member, so obviously he must be having special knowledge about the relations in the family. So the person must be such, he had special knowledge about the relationship. And finally, the statement is made before any dispute arose. So this is only to secure against the biasness which the 4 was talking about. So 3 requirements under 5, the statements is related to the existence or non-existence of any relationship, whether the relationship is by blood, marriage, or adoption. The second requirement is that it is made by such a person who had special knowledge in regard to that relationship or is expected to know something about it. And finally, the statement is made before any dispute in regard to that has arisen. Okay. Now come to friends, come to 6th point, is made in will or deed relating to family affairs. When the statement relates to the existence of any relationship by blood, marriage, or adoption between persons deceased, and is made in any will or deed relating to the affairs of the family to which any such deceased person belong, or in any family pedigree, or upon any tombstone, family portrait, or other thing on which such statements are usually made, and when such a statement was made before the question in dispute was raised. So as far as 6th is concerned, it is also very similar to the 5th point. Again, 3 requirements are coming to the fore. But there is one big difference. As far as this 6th point is concerned, it is not, it is only covering one of the circumstances. Though the person is not available before the court of law to dispose the matter, but the reason for his non-availability is death, not any other circumstance, death. Once this requirement is satisfied, what is that? The nature of the statement. The nature of the statement is hinging upon, again, as was the case with 5, the same, the relationship. And the relationship can be blood, marriage, and adoption. So as far as the first requirement is concerned, is same of 5 and 6. The statement is hinging upon relationships. Okay. But the second requirement is that the statement is made by a person who has died. Okay, who has died. Third important requirement is that this statement is made either in a will, obviously a particular person makes a will, or any other document, family document, in which, through which, okay, which are the normal documents which decide property and all other family matters. So that statement must be mentioned either in a will or in a deed or in a family pedigree or in a tombstone or in a family portrait. These are all examples of documents which are used by family members to write important things. Okay. So the statement must be made in onto any of these category of things. Okay. And finally, the statement was made before any dispute arose in regard to such a relationship. So again, protection against biasness. So four requirement under 6. What are those requirements? Statements relates to relationship. Second, it is made by a deceased person. Third is that it is mentioned in a will, etc. And finally, it was made before any dispute arose. Okay, this is the 6th circumstance. Now, friends, quickly come to 7th circumstance. Or in document relating to transaction mentioned in section 13, clause A. When the statement is contained any deed, will, or other document which relates to any such transaction as is mentioned in section 13, clause A. So quickly go to section 13, clause A. Quickly open section 13 of Indian Evidence Act. We have already covered section 13, so it will not be very hard for us to understand it. Okay, open section 13. So I am expecting that you have opened it. Section 13A says, where the question is as to existence of any right or custom, the following facts are relevant. Any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted, denied, or which was inconsistent with its existence. So section 13 was talking about the ways in which a particular right or a particular custom, what are the facts to prove these things. Okay, so this said that any transaction, any past transaction which depicts that a particular right or custom exists, that such a question had already arisen, or it depicts a situation when this custom or right was created, or it was claimed, or it was modified, or recognized, or asserted, or denied. So all of those transactions were held to be relevant facts under section 13, right? So now come to section, again come back to section 32. Okay, so what is the relevance of this under section 32? Section 32(7) is saying that when a statement is contained in any deed, will, or other document which relates to any such transaction as is mentioned in section 13 clause A. So what is the essential idea that is coming out is that if a particular statement is mentioned, is made in a particular document, whatever be the nature of document, or in a particular will or any other deed, that statement is relating to the existence, modification, or recognition of a particular custom or a particular right, that document will, or that statement made in that deed, will, or other document can be brought before the court of law and can be admitted under section 32 if the person who mentioned that statement in that deed, will, or other document, he is not available before the court of law to dispose that matter. Okay, friends. So it is a combination. That again, so what are the requirements? The person who has made that statement is not available before the court of law. Second, the statement is made either in a deed, in a will, or in any other document. And finally, the statement was related to the recognition or modification of a particular custom or right. Okay, friends. Now come to the final circumstance, that is eighth, or is made by several persons and expresses feeling relevant to matter in question. When the statement was made by a number of persons and expressed feelings or impression on their part relevant to the matter in question. Okay, friends. So in this eighth circumstance, very interesting circumstance, we are making the statements of person who are in big numbers. Okay, and what they are doing, what are these people doing? They are expressing their feelings, their own impressions about a particular fact. Okay, so what is the reason that these people are not brought before the court of law? What is the reason? That they are large in number. So obviously public has no identity. You don't know them. Just because a particular group of people has expressed something, you can't call, you don't know who actually said what we know, that public said this, but public is not a person who the court can call. So this is the reason that these people are not available before the court of law. So the first requirement is satisfied. Now the second requirement is that the statement is made by a large number of public, and third, it is expressing feeling and impression in regard to something. This is very important. This statement of the public must be an expression of their feeling or impressions. We will look at one illustration so as to understand this point. So look at the look at the last illustration, that is N. N says A sues B for a libel expressed in a painted caricature exposed in a shop window. The question is as to the similarity of the caricature and its libelous character. The remarks of a crowd of spectators on these points may be proved. So what is happening in this case? A and B, there are two parties. Okay, B has drawn something, he has created a caricature. Okay, so B is saying, the other person A is saying that the nature of the caricature is such that it is causing libel, it is causing defamation to me. Okay, A is saying that B has created a caricature. Obviously we will dispute that no, the nature of the caricature is not such, is not amounting to libel to A. So if that caricature is put in a shop, in a public shop, and it is exposed to public, so what was the impression that public got out of it when they saw that caricature? What was the feelings? So if the public also reached the conclusion that it is libelous in nature, or they also had a bad feeling about it, then these statements of the public, though they cannot be brought before the court of law because it is general public, these statements become relevant under each circumstance because it is the expression of their feelings. Okay, friends. So, friends, this was our discussion on section 32. I tried to cover the important illustrations. I know there are a lot of illustration. It was not feasible to cover each and every one of them. But friends, what I have done, I have discussed you the ingredients. I've told you the ingredients of each and every circumstance. So if you understand those ingredients, if you keep those ingredients in your mind, then each and every illustration you will be able to understand each and every illustration. Still, if after watching this video, friends, if you have any question, any if you are not able to understand any particular illustration, just write the number of that illustration into the comment box. I will give my best to explain that. So friends, I hope this lecture was useful for you. So friends, if you want to appreciate my efforts, please subscribe to my YouTube channel and connect with me on Telegram. The invitation link to my Telegram group is in description to the video. Until then, friends, be safe, be happy. Bye-bye.